Good morning, everyone, and thank you for joining us once again as we continue to explore wealth planning issues from a financial and legal point of view. This is the second in our 3 webinar series in which we're illustrating such planning issues in the context of our family. Last time, we looked at Thomas and Sarah and the concerns that they had about downsizing and gifting from the wider family perspective. Today, we're going to focus on their daughter Claire and her husband Peter and the issues that they face as they contemplate selling their business. But more of that shortly. Firstly, I'd like to introduce myself. My name is Helen Marriott and I head up the family law team at Brabner's. We've recently launched an initiative called Brabner's Personal, which in simple terms is a coming together of all the services we offer to private individuals as opposed to businesses across the firm. And as part of that initiative, we want to illustrate in these webinars just how interlinked are the various legal and financial issues facing individuals and the advantage in taking joined up advice. I'd firstly like to introduce you to my partner, Duncan Bailey, who heads up our private client team. Morning, Duncan, how are you?
I'm very well. Morning, Helen. Morning, everyone.
Thank you. And we're also delighted to be joined once again by Moira O'Shaughnessy, who is the managing partner of FPC. Good morning, Moira. How is your day going?
All good, thank you. Hi, Helen. Hi, everyone.
So Duncan and I will focus on the legal issues to be mindful of from Claire and Peter's point of view, whilst Moira will set the scene by looking at their financial planning considerations. Like last time, we'll answer questions towards the end, and you should see a box on the right of your screen. If you type in a question, then we'll aim to answer as many as possible towards the end. But again, like last time, we'll follow up on all questions and answers after the webinar if we don't get a chance to go through them all. But without any further ado, I'll now hand over to Moira, who will introduce us to the family once more. Moira, thank you.
Thanks, Helen. So, hi everyone, I'm Moira O'Shaughnessy, as Helen said, from the Financial Planning Corporation. We're based up in Ainsdale near Southport. And we work very closely with the Brabner's Personal team, and I'm delighted to be co-presenting this series of webinars with Helen and Duncan. As financial planners, it's our job to help you plan ahead and live life well. And we do that by providing the financial planning and independent investment advice you need to achieve your goals. But as you'll see today, it's a team effort. Now, last time we introduced you to our client family, and we're going to start there again with a quick recap as we look at our family tree. At the top of the tree, you'll see our grandparents, Thomas and Sarah, long retired now and in their 80s after a successful medical career for Thomas. They're downsizing and in the process are going to be releasing a significant capital sum. And they want to use some of that to help their son, John, get back on his feet after sadly having gone through a divorce with his wife, Jenny. But what they do for one, they've always done for the other. And so even though Claire has very different financial circumstances, they'll want to help her too, or her children. This week, we're focusing on Claire and her husband, Peter, as they face the sale of their business. And we're going to think about the implications for them and their family. We've got Sophie, who's married to Steve. They've got a little daughter, Alice, and there's another on the way. And they too are looking to move house to be nearer to their parents. And then we've got their son, Fred, who's living in a flat at the moment with his girlfriend, but is also thinking about getting onto the housing ladder. So, Claire followed in her father's medical footsteps at uni and she qualified as a pharmacist. Not long later, she met a medical sales rep, handsome chap called Peter, and it was love at first sight. And they're 30 years married this year. They've also been a great business combination with Claire's medical scientific approach, complementing Peter's extrovert get-up-and-go nature. They saw an opportunity to get into medical supplies in the pharmacy sector, and the rest is history. 25 years on, they've had an offer of £3.5 million for the business, and they are tempted. Now, sadly, they've missed out on entrepreneurs relief at 10% on the lot. So the tax bill is around £600,000 as opposed to the £350,000 it might have been, but they're still tempted. So now let's take a look at them and have a look at their family balance sheet and see what else they've got going on. What you can see here is they've got a chunk of cash and then they've got some money invested, which is the orange, and a chunk of money between them held in pensions. They've not yet touched those. They've got their main home, and they've also got a holiday home in Abersock. It's got a small mortgage on it of 50,000 or so, and they're minded to be paying that off now. But as you'll see, their business is their most significant asset. Now, like their parents, Claire and Peter have had a strong work ethic, and they've tried not to spoil their kids, but they have given them a good education, they've had good holidays and life experiences, and they'd like to think that those sorts of things can continue in retirement. But that comes at a price. They also like their son-in-law, Steve, and he's an independent sort. And they match the 50,000 that he had for house purchase when he and Sophie got married. They'd like to help them again now, but we're talking closer to 200, 250,000. And so as much as they don't want to alienate Steve, they would be looking for some protection for that money. And like their parents, what they do for Sophie, they'll want to do for Fred. So ideally, they'll ring fence some funds for him and maybe even something for grandchildren down the line. But they're conscious they don't want to be too generous too soon. And in fact, they've got to think about their own long-term financial security. Because what they do realise is if the business is sold, their income will completely stop. Now, they've done some expenditure analysis, they've had a bit of a tot-up, and they reckon they need about £100,000 a year net, rising with inflation, to see them right. But there's a bit of a wish list too. They'd like to do a new kitchen, get a couple of cars, and also spend a bit of money on Abersock, which they view as a long-term hold and really would like to keep in the family if they could. So they know they've got some big decisions to make, a lot to learn about tax and investment and what they need to do to protect and preserve all they've worked hard to achieve. Now, last week, we introduced you to something called lifetime cash flow modelling. Sorry, not last week, last time. And this time we're going to look at that again and present something called an AIMS model. AIMS, or Asset and Income Modelling, helps you look ahead and look at a range of scenarios, and in this case, ask the most important question: how much is enough? Now, it's only as good as its assumptions, so we've got to make sure that this is bespoke to them with all the wish lists and everything thrown in, and we make sensible assumptions about investment returns, tax and inflation. And those things can, of course, change. So looking at a range of scenarios and regularly reviewing these models is really quite useful. So let's start with our first AIMS chart. And what you can see here is we're looking at the sale of the business. No gifting yet, but we have factored in the £100,000 a year and the wish list spends. What you can see at the bottom is a solid block of blue, and that is the property assets, their main residence and Abersock, broadly rising with inflation over time. Then you can see we've got a pale blue block, and that's the cash sale proceeds coming in from the business. And for the sake of simplicity example, we've just left that going into cash, which is the green. Their investments are the orange and remain broadly intact, as do their pensions in that solid purple burgundy coloured block at the top, until way down the line. Now, a brief comment on pensions, if I may. Under current legislation, which, as you probably know, pensions legislation changes a lot, but under current rules, pensions sit outside of your estate and are inheritance tax free and can pass on to the next generation with no tax. Therefore, ideally, Peter and Claire might like to keep those funds intact outside of their estate and pass them on. If only it were that simple. There are other things to think about. Although they may pass on inheritance tax-free, there can be an income tax charge if they pass on after age 75. They also need to think about a thing called a lifetime allowance, which they both might hit, because that too could bring a tax charge. And within those pension pots, they've got some tax-free cash entitlement of 25%. And they may want to think about whether they need to take that for their own needs or for further gifting. So, unfortunately, no one size fits all. And it is important to think about the many factors that can affect the withdrawal strategy on pensions. Your tax position, your children's tax position, which is hard to gauge, and factors such as health. But the main point is to note is that pensions and estate planning decisions these days definitely do go hand in hand. Now, what about back to our question about how much is enough? That 3.5 million, is it enough? Well, on the face of this, it looks okay, but you don't necessarily get everything up front in a deal, and that might not be the shape of this. I can tell you, if they don't clear 3 million, we're going to be eating into that pension pot. And if in fact that expenditure analysis they did wasn't quite right, and they needed, say, an extra £25,000 a year, not only will they rattle through the pension eventually, but by the time they get to their parents' ages, they'd have to sell Abersock. So, thought about expenditure is really useful to spend time on. But what about inheritance tax? Let's look at another scenario, and there's a little bit more going on here, so bear with me and I'll talk you through. The solid block of blue at the bottom is still there, the main residence in Abersock. But in a moment, Duncan's going to just touch on how they might want to think about gifting a holiday property, if that's something that's important to them, to keep that in the family. Here what we see is again the blue sale proceeds coming in, but this time a few things are going on. The capital gains tax goes out, the wish list spends go out, and we've also given away £250,000 to Sophie. And some of that money's gone into the orange investment pot because they need an income from somewhere. Now, the important line for us to look at here is the black line. And it's very important to be aware of the impact that the sale of a business has on your estate. Because what you can see is before the sale, that black line is about £777,000. And then it jumps up to around £1.5 million as those business proceeds come into the estate. Because just like pensions, a business sits outside. Once it's turned to cash, it's on the page. And that means the inheritance tax jumps to around 26% of their estate. Now, if you follow that black line, you can see it does start to go down as the gifts that they've made start to fall off the estate. And important to note there too, tax starts to reduce after just 3 years. So our mantra of give and live is a good one to keep in mind and get the clocks ticking as quickly as possible. What you can see then, at around age 70, we've got the burgundy block going down slightly. And that's because they've taken their tax-free cash in this example and given that away too. And at the end of the day, we've got an inheritance tax liability that's come down to around 10% of their estate. And they've given away over £750,000 in that timescale. Now, there's lots of variables going on here. I appreciate that. And as I said before, there is no one size fits all, unfortunately. But the key is to realise that a decision in one area, say pensions, will have a knock-on effect on other areas such as tax, investment and estate planning. So it is important to take an integrated view, and that's really what financial planning and working collaboratively with all your advisors is all about. But back to that final question of, is the £3.5 million enough? It's important that Claire and Peter factor in all of their needs and that they do their number crunching well in advance of any decision to sell. We've got to bear in mind that this is their life's work, so it's got to be enough to provide for them, but also hopefully to allow them to continue to help the family. This investment planning hierarchy shows you the fundamental building blocks that they need to put in place, not just after a sale, but ideally beforehand as well. So they're not completely dependent on an exit for their own financial security. What you can see in this little simple diagram is the blocks they need. So a solid cash reserve, then an investment strategy that is geared up to not only provide them with an income, but also some capital growth to protect against inflation long term. And then there's the legacy planning, looking at how they can help their children, their grandchildren, or other causes that are important to them. And if they can tick all of those boxes, then there'll be lots of other choices too. So it probably goes against the grain, and this is certainly the case, I think, for many business owners. They're so used to putting the business and family first. But this time, Claire and Peter need to put their own needs first if they're going to get this right. Now, I'd like to hand over to Duncan, and he's going to talk about the estate planning considerations that flow from all of this. Thanks, Duncan.
Thanks very much, Moira. So I'm going to pick out 3 topics to discuss. First being tax-efficient will drafting for Claire and Peter. The second being the importance of them having powers of attorney in place. And the third being lifetime giving, which Moira's been touching on. So as Moira explained, their business currently qualifies for an exemption against inheritance tax called business relief or business property relief. This means that there's going to be no inheritance tax, or IHT as it's more commonly known, on it when they die. However, once the business is sold and they have cash instead, this is no longer exempt from inheritance tax. which means that they've currently got some great tax planning opportunities to try and take advantage of. So let's assume that they want to leave all of their combined estate to the survivor on first death. And let's assume Peter dies now and Claire dies of a broken heart a year later, having then sold the business, which she can't or doesn't want to continue running without her beloved Peter. So Peter simply leaves all of his estate, including his half of the business, to Claire. Spouse exemption will apply, meaning there's no inheritance tax on his death. Claire then dies, leaving the £3.5 million sale proceeds from the business to the children, which will then be taxed at 40%, meaning a £1.4 million inheritance tax bill. I think I've got my maths right, but Moira and the accountants amongst you will be shouting at me if I've got it wrong. So a fantastic tax planning opportunity in this case is for Peter to leave his half of the business under his will to a trust for Claire and the kids. Business relief would still mean that there's no inheritance tax payable on his death, but the difference is when Claire dies. The sale proceeds on Peter's half of the business will sit in this trust, which is outside of Claire's estate. And this would mean that it doesn't get taxed on Claire's death, resulting in a £700,000 tax saving for the kids. However, Claire is still able to access and benefit from the money in the trust. So it's very much a case of having your cake and eating it in this instance. In the first webinar, we talked about Claire's parents, Thomas and Sarah, leaving her inheritance on trust for her. Had they done this, her inheritance would similarly be available for her to access, but sits outside of her estate, and so would have avoided losing 40% of this in inheritance tax on Claire's death. If a trust wasn't used and given 40% IHT was paid when her parents died, this means the inheritance is now suffering an 80% tax rate. Now, another way a trust can help Peter and Claire themselves is how they benefit their children. The kids are relatively young still, at least in the eyes of mum and dad. They're just starting out in life and they're in relatively new relationships, particularly Fred. Claire and Peter, as Moira explained, want to provide the maximum benefit they can for the children, but they don't want to give them too much too soon. They don't want to take away their drive in life, and they don't want to see a large inheritance being lost in relationship breakdowns. They also want to ensure both Sophie and Fred have had the same amount overall. A trust in the wills for Claire and Peter to hold the combined estate when they're both gone can help with all of these wishes. It's flexible enough to permit the trustees to work out how to equalise the amount each of the children gets. It would enable the trustees to decide when and how the children benefit from their inheritance, so it can provide the greatest benefit to the kids in accordance with Peter and Claire's wishes. We touched on who can be trustees of a trust in the first webinar. Now, in this instance, having just the children, Sophie and Fred, as the trustees might not actually be a very sensible idea, as they could thwart the intentions of Claire and Peter and just wind up the trust and dish out the assets between the two of them. However, it's often nice for them to have some control over their money, together with perhaps an independent trustee in this example. That might be the right kind of answer here. This could be another family member or a friend, or often people will have a professional such as a solicitor to carry out this role, because they've of course got no axe to grind and can remain impartial. Now, the second topic of the three I was going to talk about were powers of attorney. Now, again, I touched on these in the first webinar and explained how crucial it was for Thomas and Sarah, particularly Sarah in that instance, to have these in place. Now, the same is true for Claire and Peter. Even though they're actually much younger, they still need to have these in place so that they decide who looks after their affairs if they're unable to. Old age, of course, is only one cause of a loss of capacity. An accident, illness, stroke, such like, can all just as easily result in a loss of either your physical or mental capacity. If you don't put powers of attorney in place, an expensive and lengthy application needs to be made to the court, who will decide who will deal with your affairs, which isn't necessarily who you would have chosen, so be warned. Now, my final, third and final topic was lifetime giving. As Moira talked about, lifetime giving is really effective for reducing inheritance tax. Moira made reference to Claire and Peter looking to give away their holiday home in Abersoch in Wales in an attempt to avoid having to pay inheritance tax on it, which, if they've got a large bill on that, would potentially mean Abersoch having to be sold to pay the IHT bill. Lifetime gifts have a number of tax issues that need to be considered. With the Abersoch property, the main taxes in play are going to be inheritance tax and something called capital gains tax, or CGT. And CGT is essentially a tax on profits you've made on assets. Now, for a lifetime gift to be effective for IHT, you need to A, have survived the gift by 7 years, but also not have reserved any benefit in the assets that you're giving away. So in the case of Abersoch, Claire and Peter's continued use of the property on holidays could cause what's called a reservation of benefit, which would mean the gift would be ineffective for IHT. The easiest solution would be for them to pay rent as and when they use the property. And given they only use it occasionally on holidays, it shouldn't be too expensive. A gift of this house would also be a disposal for CGT. Assuming it increased in value, there could be some tax to pay on that. And if this were significant, they might actually consider giving the house to a trust rather than direct to the children. Not only will the trust provide more control for Peter and Claire, because they could be trustees, for example, but the trust can also provide the ability to hold over the gain, meaning that the trust acquires the property at the same base cost as Claire and Peter had, so no CGT needs to be paid on the transfer at this stage. Claire, as Moira explained, Claire and Peter also want to help with property purchases, but they're not entirely comfortable with just giving the money to the children for this, and so they're thinking about doing it by way of a loan, so it can be called back if things don't go according to plan. The loans, of course, still sit as an asset in their estates for IHT purposes, but in reality, they're not really intending to call them back in. So effectively, it's a double whammy. It's not really an asset, but it's something you're having to pay inheritance tax on. So as a result, clients like the idea of retaining the loans, but giving away the benefits of them, and often use a trust to receive the loan. They can control the trust, and thus have control to be able to call in the loan if needed, but it gets it outside of their estates for IHT. Now, before I finish, I just want to pick up on one other thing that Moira mentioned just earlier. As well as sorting out their wills, the powers of attorney and possible trusts, Claire and Peter do need to ensure that their pensions pass as they wish. Pensions will usually pass independently of your will and follow a nomination that you leave directing who the pension passes to and how. And thus it's really important to firstly have the nomination in place, but also to keep these up to date. Often they'll just simply be in favour of a spouse, but to maximise flexibility on how the pension can be passed, the kids should often be named on the nomination too. Occasionally a trust can be used as a recipient where more flexibility is needed, and this is commonly in the case of a second marriage, for example. But pension planning is a topic all in itself, really, which sadly we don't have time to cover in more detail now. You can see Helen's popped up, so she's ready and waiting to go in the wings. So I'm going to pass over to Helen now.
Thanks, Duncan. As ever, it's a balance, which is why it's really sensible to look at planning options from a variety of angles. As a family lawyer, then effectively, I often wear two different hats. I have to look at asset division when it's all gone wrong, which can often be an exercise in damage limitation. But additionally, I can advise at the planning stage so as to offer solutions to protect family money as best as possible in case it might all go wrong at some point in the future. And the difference, of course, is that in the latter scenario, hopefully emotions are more in check. In a divorce or a separation, then obviously emotions can cloud clear thinking. Today, I want to focus briefly on 2 legal issues and 1 practical issue. So firstly, if Claire and Peter do gift £250,000 to Sophie, then how can they ensure that that is protected in her hands? Secondly, what about Fred? He is not married, but he's cohabiting and he wants to get onto the property ladder. So what should he be thinking about? And then thirdly, the practical point, how do you even begin to raise these issues with the younger generations? So let's tackle firstly the potential £250,000 gift to Sophie, assuming it is a gift. Maybe listen to the first webinar when I discussed that issue. But here they are married, and I'm assuming that when they married, they did not have a prenuptial agreement. So it's important for Sophie and Steve to be clear about the intention that her mum and dad have in giving her that money now, and being clear that whilst Claire and Peter don't want to upset Steve at all, they do want it to be treated as money for Sophie's benefit. Well, as I said last time, Sophie could keep it as an investment in her sole name. And if the monies are never mingled with assets that Sophie and Steve build up together, then she's got a very good argument to ring fence that for herself if they later separate. But of course, there's still a risk that the family court will see that as an asset to which the court can have regard and can treat as a resource available to meet needs. So is there anything else that Sophie and Steve could do? Well, they could think about entering into what is called a post-nuptial agreement, rather like a contract, in which they set out how they want their finances to be divided if they ever do separate. And what they should do is make it very clear what they see as matrimonial property and therefore available to be shared, and what they want to exclude from that sharing principle. For example, they could say that any further gifts or inheritances that each of them might receive in the future will be kept by the party who received it, free from any claim by the other. And even if the monies are put in trust, then a post-nuptial agreement could also be used to further reinforce that idea of asset protection. Like a prenuptial agreement, i.e. a contract you enter into before marriage, a post-nuptial agreement, which is entered into after marriage, is not automatically binding, but can carry significant weight. One point to mention before we move on to look at Fred and his wish to get on the property ladder is to talk about property ownership per se. When you're buying a property, do think carefully about whose name it is to be put into and how any shares in that property are to be defined. You can own a property jointly in different ways. So to explain, you can own a property as joint tenants in law and equity, which means both of you own the whole lot. And if one party dies, the survivor gets the whole property. And the alternative is to own the property as tenants in common, which can be in equal shares or unequal shares. And if you own the property as tenants in common, then the deceased share passes to whomsoever they have nominated under the terms of a will. And if there is no will, then it will pass in accordance with the intestacy rules. Now, the intestacy rules will provide enough material for a whole webinar in itself, but hopefully everybody listening does have a valid will in place. And if not, please speak to Duncan as he can help you get that sorted. But you could own a property as tenants in common in unequal shares. So, for example, if you buy a property for £300,000 and one party puts in £200,000 and the other puts in £100,000, then make sure that there is a declaration of trust declaring the beneficial interests are held as to 2/3 to party 1 and 1/3 to party 2. Moving on to Fred. Then if he receives monies from Peter and Claire to get on the property ladder, and let's face it, that's a very common theme, then he needs to be clear about how that property is owned. As of course, it's not just a matter of how the property was purchased that needs protecting, it's also being mindful of how they deal with any contributions to that property going forward. So a cohabitation agreement is very useful as well. The worst thing in the world here would be if Fred buys a property and puts it in the joint names legally and beneficially of himself and his girlfriend at the outset. Effectively, he's given away half of that sum. Now, again, as a family lawyer, I am aware that very often I have to give extremely unpalatable advice. But the key, I think, to try best to mitigate that is for all the professionals involved, so that's lawyers and professionals dealing with financial planning and tax, to be aware of issues from another perspective. And this boils back to the Brabner's personal initiative. And in simple terms, we do understand just how much hard work goes into building up assets over time, and the necessity, therefore, of planning and getting your financial situation in order. It's an ever-moving picture that requires bespoke advice from trusted professionals who are working in tandem so as to give you peace of mind. Many people very often ask for practical tips on how to raise these issues with their partners, their children, grandchildren, and I have to admit that there is no easy answer to that, as very much it depends on the nature of the relationship. Sometimes the wish not to offend, or indeed not to talk about money per se, means we don't talk about issues in the family at all. And whilst of course it is a balance, because many people may not want the younger generation to know about the extent of family wealth, for example, but in my experience, it is easier to talk about gifting and planning and asset protection when people are in a calm and rational frame of mind. Maybe by introducing the concept of wealth planning with the grandparents and parents, and then by them educating the younger generation. I'm now going to pass back to Moira to summarise. If you're ready, Moira, thanks.
Thanks, Helen. So what are the key takeaways that we've got from today? Well, hopefully, first of all, you've all seen that financial planning is not just about numbers, it's about families and addressing their concerns and their worries. Although I'm sure you'll have seen this week that the numbers are pretty important too, to get them right. But you've hopefully also seen that actually by working together, we can help you take an integrated approach to your planning, and there's real value in that. I'd like to just briefly remind you of the 3 steps of the financial planning process that I shared last time, because this actually reflects the way we all work in practice. Those 3 steps are quite simple: understand, plan, review. This week really it's been all about building understanding of the options you face and their implications. The decision to sell a business is life-changing, and time spent well in advance doing your numbers and understanding all of the issues that we've touched on today is time that you will never regret. The sale of the business also, as you've seen, has a very significant impact on your estate. And so, as Duncan flagged up, a review of your will, of powers of attorney, of the use of trusts is really important. And finally, as Helen's made clear, I think we'd all agree that it's a part of all of our jobs to help you prepare the next generation for the responsibilities that come with managing family wealth. And so education should start early, and we're all here to help you get those awkward conversations going. And speaking of awkward, let's think about maybe now having some awkward questions, and I'm hoping that Duncan's going to be ready to fire that up and take the first one. Thank you.
Thanks, Moira. So I can see a number of questions have been coming in. Whilst Moira and Helen catch their breath, let me try and take one of the first ones. So whilst Moira was talking, I could see the one came in on the back of what I was talking about, asking whether business relief is the same as business property relief. So the simple answer is yes. For some reason it changed in name, but name only, a couple of years ago. And essentially business relief or business property relief is an encouragement for people to own and to run trading businesses. But the business does have to be a trading business rather than, for example, an investment company. You need to have owned it for a couple of years. But if you do qualify, and there's a few other caveats as well, but if you do qualify, it can give up to 100% relief against inheritance tax on your business, whatever the value. So it can be an incredibly valuable relief. So it's essential you take advice to ensure that both you and indeed the business do qualify for that. Because of this relief, it also provides the opportunity to give away shares into trust prior to a sale of a business, which can have huge IHT benefits and definitely needs to be considered ahead of any possible business disposal. Helen, Moira, you see another one that she's right?
Yeah, I've got a pensions one. I'll go with that one. How much can you put into pensions? Couple of points here to think about. Firstly, there's a thing called the annual allowance, and that is set currently at £40,000. So you can put £40,000 typically into a pension, provided you've got the appropriate earnings in most cases. Now, what that means, just in simple terms, is if you're making that contribution personally, you'd make a contribution of 32,000, and then basic rate tax relief added to get it to 40, and then you could claim any higher rate tax relief. And one thing that springs to mind, and I'm doing this because of my own daughter, is actually youngsters can often forget to claim their tax relief because they've hit into higher rates of tax and perhaps they're not used to doing tax returns. So it's something to flag up. And next time when we look at the next generation, I've just made a note then to cover that. You can also carry forward that 40 from a couple of years back if you've not used it. But one thing that we do run into quite a bit is that high earners these days are very restricted on pension funding. It used to be if you earn more than 150,000, that 40,000 limit is tapered right down to 10. Changed it just recently. The limit's now 240,000, but there's still people who will breach that, and in some cases it means that your maximum contribution is down to 4,000. So you have to now these days, for high earners, be looking at other alternatives to pensions, sadly. And one point that you can also trip up on, sorry, I'll stop shortly, is that total income is what counts, not just salary. So rent, dividends, interest, you've got to do a bit of a tot up. But your accountants will know this inside out, and financial advisors too, and there's some handy little calculators online. So when we do the Q&As, perhaps we'll pop something in there for that. Okay, thank you.
Thanks, Moira. Shall I answer one? I've got one here, which is how do you decide what is a fair settlement? I think that's an excellent question. I spend my professional life trying to answer that. But as I've said previously, we have a discretionary system in this country, which means the court has a very long list of factors to consider. So the length of the marriage, for example, the ages of the parties, the ages of children, earning capacity. And then on top of that, the court's got very wide powers in terms of how to decide how to distribute assets so as to achieve fairness. And what I always do when I'm advising is to try to sense check my advice by thinking, for example, if I'm acting for the husband and I've worked out what I think the settlement parameters are, if I were acting for the wife, what would I be saying to her in receipt of that advice, sort of that offer, if you like, from the other side? The family court always likes to encourage compromise and early settlement, but of course there's no one right answer. In some cases, though, I would say it's fairly obvious how the court is going to deal with things. Say, for example, it's a short childless marriage, parties are in the 30s, relatively few assets, then the outcome is going to be pretty clear cut. But in a long marriage, say, where one party doesn't work, we're nearing retirement, say there's a disparity in pension issues, then of course it's not that clear cut. So I think, as Moira said earlier on, there is not one size fits all, I think, for everything that we're doing here. But I hope that helps answer that one.
I can see that there's a long question come in. We'll answer all of the questions that we're not able to with sort of some follow-ups, but just picking up on a part of the question that's come in is relating to whether there's a limit to how much money you can give away. There's no, in terms of lifetime givings, there's no limit. People sometimes get confused by a figure of £3,000 that gets bandied around, but that's not a cap as such. It's just the sum that gets ignored, even if you don't survive the usual 7-year period from making a gift. But as I say, we'll pick up on the other bits of the question that have been raised towards the end or after. Moira, Helen, do you want to?
Yeah, I've got it's a bit of a tongue-in-cheek one, but I'll take it. How can you possibly know how much is enough until after the event? Yeah, I get the point. What we're not trying to do here is crystal ball gazing and think that we can predict the future, because we all know life throws swerve balls at us and you never quite know what's around the corner. But I think there is merit in attempting to look at a range of scenarios, and that's the value of this sort of cash flow modelling. You can look and see what breaks it, and I guess that's probably the most important thing to learn. The other thing too, and we have found this in practice over many years, I've been doing lifetime cash flow modelling 25 years plus. There's something about seeing it visually, something about seeing something on screen and playing what if that's quite useful. We don't all live our lives in spreadsheets. Sometimes seeing a few pictures really brings it to life, and I think it does actually get the conversations going, not just for the next gens so much, but even just between, you know, a couple like, say, Claire and Peter looking at this together. They'll look at it from a different angle, and so there is merit in it. But I take your point. You know, you've got to go into this knowing that things might not pan out the way you expect.
I think if I jump in maybe with one more question from my perspective. Can the family court attack a trust? The simple answer is yes, it can, but that doesn't mean it will. The court's got a very wide discretion, as I keep saying, wide powers and a wide discretion. The party who is a beneficiary to a trust should declare the existence of a trust within any court proceedings. But in terms of how it's going to be considered by the court, will be dealt with by reference to how it was actually treated during the marriage. So say, for example, a beneficiary always receives a regular monthly payment from a trust, then it's reasonable to assume that that's going to continue. If, by contrast, a party has never had anything from a trust, then the trust is going to be far less relevant. But in simple terms, I think the point here is take advice not only in the setting up of the trust, that's a Duncan point, but also how to deal with it from a family perspective. You know, how have the trustees exercised their discretion? That could have a bearing, if it's a discretionary trust, in terms of a settlement. A word of comfort, though, I do want to say that the very existence of a trust clearly denotes that there's a protective wrapper around family money, so it does make it much harder for the family court to attack it. Hope that's helpful. Shall I pass back to you, Duncan?
Yeah. So there's a number of questions. I'm conscious of a time, but there's a number of questions coming through relating to gifting, lifetime giving, powers of attorney, and trustees. And actually, I think we covered some of those in the first webinar. So what I'm intending to do is, if we send at the end of this, we'll send out the questions, the Q&As that we did from the first webinar. We'll also set out the questions that we've been answering in this one as well, just to repeat. And then there are some questions, a number of questions we've not got round to, which we'll cover and send out answers to post this webinar. And before I wrap up, after the first webinar, we did actually have some really useful requests for topics that people want to see and be covered. We've been able to incorporate some of those into this webinar, but do keep those coming through, because we'll try and do the same with the third webinar. And I suspect, to the extent that some of them are large topics that we just can't shoehorn into one of the webinars, we may do a separate webinar on specific topics. So if there are things you want to hear about, then do shout out. So the final of this series of 3 webinars is going to be in 2 weeks' time. In that one, we're going to be looking at how poor old John can rebuild his world, and issues facing the next generation. And also possibly looking ahead at what possible tax and legislation changes might be on the horizon that might impact on your estate planning. But until then, thank you so much for joining us yet again. And on behalf of all three of us, I wish you all the very best. Thanks again.
Thanks, everyone. Bye-bye now. Bye-bye.
Bye-bye.